All right, we take you back to the Western Cape now and take you to my colleague reporter Lulama Macha. A very good morning, Lulama. Now, you are among those reporters that have covered the Phala Phala matter extensively, at least the parliamentary aspects thereof. Just talk us through the timeline. It starts in 2020, yes, this is now in 2022, brought to the fore by Arthur Fraser. But by the time it got to Parliament, where it was due to be voted down in 2022, politically charged time for the African National Congress that was heading to its own elective conference. Just perhaps remind us of the facts thereof before you give us a reaction from some of those gathered out there.
Welcome back to the Western Cape High Court. Indeed, when we speak about why we are here today, it dates back to when there was a burglary at President Cyril Ramaphosa's Phala Phala farm, and a case was opened. Immediately when that case was opened by Arthur Fraser, that matter then was brought to Parliament, whereby political parties in Parliament wanted the President to answer on that. A week after that case was opened, the President came to Parliament to deliver his budget vote speech. That is when, on the day that he was here, the EFF started asking questions. In fact, they did not want the President to address them. They were saying that he is a delinquent president. They disrupted the proceedings. But after some time of those disruptions, the President ultimately did manage to address the House and tabled his budget vote speech, indicating that he will follow processes, he will abide by court processes, that the court processes must be allowed to take its case. After that incident, then the President, some of the political parties, especially the opposition political parties, wanted more accountability. They did not want to wait for, they say they will not wait for the court processes, but Parliament should be able to do its own work or investigation on this matter. Mm-hmm. And then they approached the former National Assembly Speaker, that when she appointed that panel, which was headed by former Chief Justice André le Grange, that panel was given a time frame to investigate whether the President, whether there is a prima facie case for the President. And then after the time frame has lapsed, that panel released a report. That report, then, the recommendations of that report was that the President, there is a prima facie case against the President, that he has violated his oath of office. And after that report, how Parliament dealt with that report then, they did not establish an impeachment committee. That report was taken to the National Assembly and it was voted. It received the majority of votes, and before, in fact, that report was voted to the National Assembly, the President did make an initiative of taking that report for review. Mm-hmm. But after it was voted against by the National Assembly, then he withdrew that review application of the Section 89 independent panel report. So a couple of years later, in fact, on the day the National Assembly voted against that report, some of the opposition parties indicated on the day that they will take the matter further. They will not let it lie down. They approached the court on that. And then coming to now 2026, that is when the matter was heard actually years later, but it took time for the judgment to be released. And then this year in May, the Constitutional Court released the judgment on that, and the judgment was that the National Assembly must establish an impeachment committee, and that Section 89 panel report be taken to that. Indeed, the Speaker of the National Assembly, the current Speaker, Thoko Didiza, established that 31-member impeachment committee. Then she also took the report to the impeachment committee. And after that process kick-started, the President approached the Western Cape High Court, indicating first that he is going to take that Section 89 panel report to review. Remember, previously, he withdrew that application after the National Assembly voted against it. So the first thing he did was to approach the Western Cape High Court to review that Section 89 independent panel report. The second thing he did was to approach again the Western Cape High Court, seeking that the court must interdict the impeachment committee processes. Then the matter was heard last week for 2 days. Today, the judgment was delivered and the interdict has been granted. What are the arguments that some of the legal representatives have been putting? For instance, we've heard about prima facie evidence versus sufficient evidence. The legal representatives of the President were arguing that this panel, the Section 89 independent panel, did not have sufficient evidence. It relied on prima facie evidence for the President to have a case to answer. And their argument is that there was already a prima facie evidence when former National Assembly Speaker Nosiviwe Mapisa Nqakula established that panel to look into this matter. Therefore, the report should not be talking about prima facie evidence, but rather sufficient evidence. And some of the arguments also that the legal representative of the President, Advocate Avim Trengove, argued was that this impeachment, that Section 89 panel report, it can never be used as a basis to kickstart the impeachment process when its validity has not been tested. So he's saying that this process of testing the validity of the Section 89 independent panel report must be allowed to take place before the President, before the impeachment committee kickstarts its process. He's saying that the President is not running away from accountability, but he wants to be given time until September for that Section 89 independent panel report to be heard before we look, or before the impeachment committee look into whether or not there are grounds for the President to be impeached. And he's also saying that the Section 89 independent panel report failed to determine whether the President committed the violation he did intentionally. He's saying that the Constitution, when it speaks about impeachment, it says that the incumbent must have violated or committed a violation knowing very well that he is doing that. So he poked some holes on the report of the Section 89 independent panel report. I guess hence today the Western Cape High Court granted him that interdict for long.
Lulama, you so eloquently narrate the facts of this matter, specifically the important one being when you state that it was indicated that there was already prima facie evidence when Nosiviwe Mapisa-Nqakula went on to establish that three-member panel, that perhaps the panel now was supposed to go beyond prima facie and speak of sufficient evidence. But I suppose the broader conversation in society would be, was the panel not set up for failure because they had limitations insofar as their terms of reference were concerned? If you're not going to be allowed to subpoena, you're not going to be allowed to cross-examine, then essentially the outcome will be quite limited and probably bring you back to just that kind of a result of possibly again entertaining or playing in the realm of prima facie evidence yet again if you cannot cross-examine. But we'll leave it there for now. But thank you very much for that comprehensive wrap